Well, good afternoon and welcome everyone to our webinar, Just Cause Terminations. While I introduce myself and our speakers, I'd like you to just have a moment and take a look at some information on the screen in front of you, which will be of assistance to you during our presentation. My name is Matt Link, and I'm a Toronto-based partner in Fasken's Labor, Employment, and Human Rights Group. And I'm very pleased to be joined by a couple of colleagues of mine, Bruce Graham, who's an associate in our Calgary office, and Anthony Panacci, who is an associate in our Toronto office. As part of today's session, we're pleased to say that we have a polling feature which encourages active participation on your part. And additional information about that is on the screen. We'll be polling the audience on some did the employer establish cause questions and see what you think the answers are. You can participate in the poll by clicking on the polls tab on the top right of the webinar screen and enter your name. And when we begin the poll, your voting options will appear in the polls tab, and we'll see how everyone does. And with that, let's get started with our presentation. It's a fully packed day today, and on the agenda, we want to review with you a couple of starting items before we get into some recent case law. And so we'll briefly look at the foundational legal principles with respect to just cause, how to establish just cause, talk a little bit about the concept of progressive discipline and its importance in assisting you as employers to establish just cause, importance of investigating and documenting situations where ultimately you may want to raise just cause as the result of that investigation, how to most properly communicate the termination to the employee before then reviewing a number of recent cases in a number of different areas of interest to the audience. And so with that, what I'll do is start by turning it over to my colleague Anthony, who will go through some foundational legal principles. Anthony.
Thank you, Matt. So I'll start with a simple question and I'll give an answer. The question is, what is just cause? And the simplified answer is just cause is considered the capital punishment of employment law. When you compare a just cause termination to other forms of discipline, like a warning or a suspension, a just cause termination is considered to be the most severe form of discipline. There is no more severe form. And because it's the most severe form of discipline, a just cause termination is typically appropriate only if the employee has demonstrated they don't intend to comply with the terms and conditions of employment. And to frame it differently, just cause exists where the employment relationship is simply no longer viable. And in the words of one of our courts, they've explained that just cause misconduct is conduct which goes to the root of the contract with the result that the employment relationship is too fractured to expect the employer to provide a second chance. Next slide, please. So what are the specific types of misconduct that are considered to get you there? And to help simplify things, I've tried to two buckets. The first bucket is for the typically intentional types of misconduct that you think of when you think of misconduct. So things like theft, insubordination, dishonesty, and the list goes on. The second bucket is for forms of misconduct that might be categorized for employees who just might not be cut out for the job. So they're not necessarily doing anything intentional to harm the company or to further their own interest. They might just not be great at their job. And so those types of misconduct, it might help to categorize those into a second bucket. Next slide. And so that brings us to another question of, why does just cause really matter? And in certain contexts, employers are not even allowed to terminate unless they have just cause. So for example, in the unionized context, collective agreements require an employer to have just cause before ending the employment relationship. And if an employer terminates without just cause, an arbitrator can reinstate the employee and also award full back pay for the entire period of time. So it can be a very costly mistake if it happens. Non-union employees also have just cause protections in some jurisdictions. And so for non-union workplaces that are governed by the Canada Labour Code, an employee can file an unjust dismissal complaint if they're a non-managerial employee with at least 12 months of continuous service. In Nova Scotia, employees with more than 10 years of service can file a labor standards complaint as well. And there's a similar type of protection in Quebec. And in terms of workplaces that don't require just cause for termination, you can terminate on a without cause basis, but typically the downside is that it triggers termination entitlements like notice of termination. The most common entitlement that we deal with is reasonable notice of termination at common law. And for anyone not familiar with the common law, it's basically the law that develops at each time a court issues a decision. And what the common law provides is that if you are terminating an employee on a without cause basis, you have to provide them with reasonable notice of termination. And that can be quite significant. You know, there are cases where employees were entitled to more than 2 years of notice. Big entitlement. But the employer doesn't need to provide that notice if the employee has provided just cause for termination. So to frame it differently, just cause is an exception to the reasonable notice of termination entitlement. Now, employers can also avoid common law entitlements by implementing a well-drafted contract. Nowadays, we do a ton of that kind of work. A lot of employers have those types of clauses in their contracts, and the clauses can vary from contract to contract, but what we see a lot is the contract will say something like the employee is not entitled to the common law entitlement, and instead they are only entitled to their minimum entitlements under employment standards legislation. Perfectly legal. It's something that we see all the time, that we write all the time. The catch, though, is that it has to provide at least the minimum statutory entitlements. And again, even though generally speaking, employees have these entitlements, there also is an exception for misconduct. And if that exception is satisfied for just cause, then you no longer have to provide those minimum entitlements. Next slide, please. And so one issue I wanted to flag is that jurisdiction has their own specific exemption for the minimum standards. In some jurisdictions, the exception is similar to the common law exception. And an example is Alberta, where it uses the phrase just cause and it's not defined, so they take guidance from the common law. There's a lot of parallels there. But when we look at employment standards in Ontario, we see it's very different. And in Ontario, the exception applies where an employee has been guilty of willful misconduct, disobedience, willful neglect of duty that is not trivial and has not been condoned by the employer. And so if we compare this willful misconduct exception to the just cause exception under the common law, the exception applies in much fewer circumstances. Next slide, please. One more. And so when an employer wants to rely on the just cause exceptions, the employer is the party that has the onus of proving it, the onus of establishing just cause. The courts don't assume that the employee is guilty and then ask them to defend themselves. Instead, the courts will look to the employer to prove that just cause existed. And as I mentioned earlier, just cause terminations the most severe form of discipline. And so it's very difficult to convince an adjudicator that there was just cause for termination and that the employee essentially has no entitlements upon termination, no termination related entitlements. There are two things that an employer typically needs to prove. The first thing to prove is that the employee actually engaged in misconduct. It's one thing to suspect that the employee has engaged in misconduct, but it's an entirely different thing to prove it to an adjudicator. And in some cases, it's tough to prove that the employee engaged in the behavior that they're accused of. But even if you're able to improve that, it's also difficult to prove that the misconduct was actually, or that their behavior was actually misconduct. So there's proving that they engaged in the behavior, and then there's proving that the behavior was misconduct. That's the first major hurdle. And if you get over it, your second hurdle that you have to overcome is you need to convince an adjudicator that the termination was justified in the circumstances. So you'll need to convince an adjudicator that termination was justified in light of the aggravating and mitigating factors. So all that to say, it's very difficult to establish just cause, and it's impossible to know whether you'll succeed if the employee challenges the just cause terminations. You'll have a sense based on the facts, based on the law, but it's difficult to know with certainty. It can take time to build up the evidence, build your case, and if the employee challenges the termination, they can drag you through a costly litigation process. Next slide, please. And so I mentioned mitigating and aggravating factors. We've listed some here as examples. And on the mitigating side, it'll be harder to establish just cause and convince an adjudicator that there was just cause if you're dealing with a long service employee, an employee who has a clean disciplinary record, if you've condoned the misconduct, you've allowed it to happen and haven't disciplined the employee, or where the employee has demonstrated remorse for their actions. On the flip side, you'll have an easier time establishing just cause if the employee had a disciplinary history, if the misconduct was deliberate, if the incident or the misconduct was serious as opposed to something trivial, and where the person was in a position of trust if they were dishonest at all. And with that, I'll turn it over to, I believe, Bruce or Matt.
Thanks very much, Anthony. Progressive discipline. It's something that we talk about a lot, and you've likely had entire presentations about the importance of progressive discipline. But nevertheless, I think it's important at least to discuss it or review it as a concept briefly within this broader just cause context, because absent a few exceptions in situations that are you call single incident or single cause offenses that rise to the level of cause, in the majority of situations, in order for a just cause case to stick, you are going to need to properly and enforceably apply some form of progressive discipline. The theory behind that is that a court or an arbitrator in the unionized setting is at the end of the day facing a situation, as Anthony described, that one court saying that termination is the capital punishment of employment law. Termination for cause results in someone losing their job and not receiving entitlement to any termination or severance amounts. It is a harsh outcome. And so what arbitrators and courts ask themselves when faced with a case that involves misconduct where the employer is alleging cause is this a situation where the employer could have substituted some lesser form of discipline short of termination or discharge. And best way to be able to demonstrate that is by using progressive discipline and doing so properly, having clear, articulated standards in writing, available and known to employees, to consistently enforce those standards, and to use progressive discipline not as a punitive measure, but as a corrective measure. And again, this is what courts will say, is that by engaging in progressive discipline, you're alerting the employee, although it may seem obvious to everyone, you're alerting the employee to the fact that what they've done is wrong, that it's a violation of policy, it's improper conduct, what have you, and you're giving them an opportunity to correct their behavior. You're not punishing them. Next slide, please. The path of progressive discipline, and again, there is no progressive discipline policy that is set in stone, and there can be situations, for example, where you may skip steps depending on the severity of the conduct. But again, in most situations, you're typically looking at a verbal, a written, perhaps 1 or 2 suspensions, culminating with a lengthier suspension and a final written warning. Important point to note, and I always try and make note of this, with respect to the final written warning. Some employers will have a tendency to sort of be non-committal in terms of their warning letters. So the line just before the signature line is, any further misconduct in the future may result in further discipline, or may result in further discipline, up to and including termination. In your final written warning, you don't want to be equivocal. You want to be very clear. This is a final opportunity to correct their behavior, and that any further misconduct will result in termination for cause or discharge. And that language can be the difference maker in terms of when a court looks at the letter and determines whether or not the employee was fully aware of the severe consequences of continuing to engage in the behavior that they'd engaged in. Next slide, please. Now, a number of my colleagues have an entire webinar on the subject of the importance of investigations and documenting those investigations. And so we'll only spend a few moments on this issue now. Next slide, please. But aside from the fact that it gives me an opportunity to do a screenshot of perhaps the greatest legal advertisement known to man, Mr. Larry Archie there, just because you did it doesn't mean you're guilty. Just want to take a moment to highlight the importance of investigations when you are looking at potential misconduct, which ultimately could result in discipline up to and including termination. How you conduct the investigation, whether it's done properly, the fact that you interview all individuals involved if necessary, that you give, perhaps most importantly, the employee an opportunity to respond to your findings, give them an opportunity to explain themselves, is critically important, and a critically important piece to putting together that termination for just cause jigsaw puzzle. Next slide, please. Again, it's a step-by-step process. We don't sort of need to review the importance of planning, the importance of documenting the investigation from the legal side of things. Again, either your internal or external counsel will have told you that legal privilege doesn't always attach to documentation. And so you want to make sure that your interview notes are very clean, that they're free of commentary. At the same time, you want to make sure that you have the documentation to support a termination for cause, because ultimately, whether it's in a non-unionized situation or a unionized situation, that documentation is likely going to be producible. And not only will you have to rely on it, you're going to want to be in a position where you're comfortable relying on it. Next slide, please. The results of the investigation, of course, are going to determine or help determine what it is that should happen in a particular circumstance. It may well be that going into an investigation, again, and most of the time, you are not going to have all the facts. That's what the investigation is for. And there may be a change in terms of the level of discipline that when you first hear about the issue from the beginning to the end. In terms of the results of the investigation as well, again, and this is why we say document, 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 you want to be able to explain the company's position to the employee, and that is prior to making a decision to terminate. So as it already indicated, but it's important to reinforce this, is to speak to the employee, interview them prior to making any decision. Once you've done that, you're going to want to then, of course, communicate those results, and they may involve termination. And Bruce is going to tell you in a moment how to best communicate with that, with respect to that. But again, if you're not putting your findings to the employee before you conclude your investigation, you may be in a position where you're then not going to be able to rely on that conduct as part of the decision to terminate. And that's where we get to the third box, which is you want to be in a position where you're able to defend the company in any kind of legal proceeding. And with that, I'll turn it over to Bruce to give you some tips and guidance on how to best communicate the termination message if you decided to go down that road.
Thanks, Matt. So there's going to be some nuance in terms of what goes into a termination letter depending on the province, but generally speaking, the rules and certainly the best practices are going to be quite consistent here. So off the bat, it needs to be in writing. That's just a must, and I'll explain a bit more why. The notice needs to provide a clear and unambiguous termination date. It needs to be addressed individually to the employee. Ideally, you're hand delivering the letter. So at the meeting or after the meeting, you'll deliver the letter by hand. If for some reason you can't, recommend you do registered mail or courier. You want to have confirmation of delivery. You just don't want to leave any room for ambiguity as to whether they've whether they've received the termination letter, and that they're aware of its contents. Next slide, please. So in terms of what goes in the letter, you need absolute clarity that the employment relationship is going to be ending on a certain date. So for example, effective immediately or effective September 20th, 2022. Again, no ambiguity about the date, and you don't want to leave any room for an argument that maybe they were going to be allowed back to work, or they might be rehired if they improved or changed their behavior. So that needs to be extremely clear. Because you're terminating for cause, you need to set out the reasons on why you have just cause. What's the basis on which cause is being alleged? These are going to be critical evidence in the event that there's a lawsuit. Also, it's going to be really critical when that employee goes and speaks to a plaintiff side lawyer. You want that plaintiff side lawyer to read a really good case of just cause and then advise their client accordingly based on those reasons. If you don't set out a persuasive list of reasons and a persuasive basis, you're inviting more likelihood of a claim from this employee. Now, you don't have to set out every single detail and every single example. In some of these situations, there might be a laundry list, but you should definitely describe the misconduct. So for example, breach of a company policy, theft, dishonesty. Then further what Matt was discussing, describe at least briefly what was the investigation that was undertaken, and critically, what was the conclusion of that investigation. If there's a disciplinary record here, go through that, include any final warnings. Again, back to the point that both Anthony and Matt have made, in termination for cause being the capital punishment of employment law, you want to show in the letter that you've thoroughly considered the record, you've considered the facts, you've considered the law, and this was a decision that was arrived at with due care and due concern. So again, if you have a whole laundry list of things that someone's done, you can just use inclusive language. So, your misconduct includes the following, or your misconduct is not limited to the following, and then bullet those points down. This is going to give you greater flexibility if there is litigation to adduce additional evidence. A few other things that just need to be in the letter, pretty basic ones here, but if there's company property, make sure that it's being indicated they have to return that. Discuss conversion of group benefits to personal plans, payment of accrued but unpaid wages and holiday pay and all that stuff. Lastly, if they have a restrictive covenant agreement or their employment is subject to that, you want to use the termination letter as an opportunity to remind them of those duties, as well as obligations of confidentiality. Next slide, please. So in terms of the meeting, there's no kind of one size fits all approach here, but typically you're best to schedule this early in the work week and do it at a time of day when the workplace is quiet. So often near the end of the day. In terms of location, somewhere private, you don't want people to see or hear what's going on, and just make sure there's no interruptions. You don't want your phone ringing or people popping into the room while this is happening. In terms of who should attend, we always recommend to have 2 individuals at the meeting, often 2 managers. So the individual's direct supervisor, and then someone else from HR in a managerial role. The key benefit here really is that you have one person taking notes, or in the event that there's a discrepancy down the road as to what was said in the meeting, you've got the word of 1 employee against 2 employees, 2 managers. And so you want to bolster your position by having 2 people present. If you think there could be a risk of animosity between the employee and one of the managers, you can always consider substituting someone in. But again, two people is always recommended. As far as security goes, this should never be the norm. It should be the exception. But if there is a reasonable basis to think that this individual could be violent, if there's a history of conflict, definitely ensure that you have security advised, that they're standing by, and that if they need to be present, they can come into the room swiftly. And if they need to escort the individual from the premises, they can. But escorting terminated employees by security out of the building can come with risks of allegations of bad faith and moral damages. So again, it should be used as an exception, not a norm. But if there is any threat, and I had this a few weeks ago with a client, if there really is a potential threat of violence, you want to make sure that security is advised and present. Next slide, please. So when you sit down in the meeting, don't make small talk. This is an important decision. You want to sit down and hand them a letter, and that letter really should have everything that you need to talk about. Communicate the decision, go paragraph by paragraph, give them a copy of the letter. Be prepared to answer questions, but don't deviate from the letter. don't get defensive, don't get into arguments. It's really important that you communicate the decision's been made and it's final. And you don't want the people in that meeting wavering either, saying something like, I wouldn't have done it this way, or this was made by the people up. You want a unified front here because this is a really serious decision, and you want to show that, again, it was given due care and due concern. Again, I think this is a question we get asked a lot, actually. It feels probably not normal, and it feels a bit uncomfortable, but you just really want to stick with what's in the letter. And what that means is you need to put a lot of care and concern into that letter. It really should set everything out that needs to be addressed, so that when you get asked a question by the employee, you can point back to that letter. Next slide, please. So again, when the meeting's done, typically you'll allow the employee to go gather their belongings and leave the premises. If they'd rather come back at another time, that's fine. You can schedule that. Alternatively, you can arrange for a courier to deliver their items. You do want to accompany the employee off the premises. You don't want them going back to their office or their desk and, deleting information, stealing property, taking information, something to be mindful of. Again, when it comes to security, just use that only where necessary. You really want to avoid embarrassing the employee publicly. When the meeting's done, I'd encourage both managers that were present to take notes. You may need those notes as evidence in the event that there's litigation. You're going to want to make sure that the employee no longer has access to company property, email access is removed, and that should be done, as well as any other IT access in connection with the timing of the termination. So you'll have to coordinate that with your IT in advance. When you're communicating the termination, you don't need to explain, and you should not explain to the company, so-and-so was terminated for cause. You can simply state that they're no longer with the company, and they can contact HR representative if they have questions. The reasons really should be on a need-to-know basis, and only those that are in a senior position should know. Really, you just want to avoid allegations of effectively disparaging or defaming the individual who is terminated. And lastly, just don't forget to inform payroll, make sure they're in the loop. They'll have to process all the outstanding wages, as well as issue a record of employment following the termination. And so that's it for me on conducting the termination meetings, and I'll send it back over to Matt and Anthony with respect to some case law.
Thanks, Bruce. So now that we've wrapped up the foundational legal principles and sort of the basics, best practices, we wanted to talk about some recent cases just to show you where is that bar when you're trying to establish just cause. How high is that bar? And to give you a preview of the next segment of the seminar, we've listed some of the categories or grounds of just cause that we often see, that we often deal with. And so we have cases on violence, harassment, poor performance, safety violations, policy breaches, and then we'll wrap up with off-duty conduct. So the first topic we have here, or the first ground, we have harassment, and it's a recent decision from involving Render and ThyssenKrupp Elevator. It was a case earlier this year where it made its way up to the highest court in Ontario. And in this case, the employer fired a long service operations manager for just cause. And in terms of the misconduct, the manager had slapped a female coworker on her buttocks. The manager tried to say it was all an accident, but that explanation didn't go anywhere. The employer had a zero tolerance policy for harassment and discrimination. And the courts accepted that the manager had violated that zero tolerance policy. Next slide, please. So based on those facts, the courts agreed that the employer did have just cause for termination. And as a result, the manager had disentitled himself to reasonable notice of termination under the common law, the more significant entitlement that we talked about earlier. But, and this is where this case gets interesting, the Court of Appeal gave us a bit of a surprising twist. The court noted that in Ontario, employees can still be entitled to termination and severance pay under employment standards legislation, even if there is just cause for termination. As I mentioned earlier, in Ontario, the misconduct needs to be willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned. And in this particular case, the court found that the manager's conduct was not willful. According to the courts, the manager had touched his coworker in the heat of the moment in a reaction to a slight. There was no evidence that the misconduct was pre-planned, and so the court did not consider the conduct to be willful. And as a result, the manager was entitled to his termination pay entitlements under the Employment Standards Act. One of the more interesting cases that we've seen on just cause in a while. Next case we have here is on violence, and it's a case out of Alberta where there was a junior employee sitting in a chair in the lunchroom, and a senior employee approached him and told him to get up and give him the seat. The junior employee refused, and the senior employee responded by hitting him on the hand and food container with a chain. The employer investigated and ultimately fired the senior employee on a just cause basis. The employer dismissed the following an interview where they interviewed multiple witnesses, including the dismissed employee and including others who were present in the lunchroom. And the act of physical violence was an isolated incident, and it didn't result in any serious physical harm to the junior employee. And in terms of the senior employee's position who was fired, he maintained that he didn't hit the junior employee and he was not remorseful for his behavior, and he wasn't accepting responsibility for his misconduct. So in terms of the outcome, the court agreed and found that there was just cause for dismissal. On the one hand, the violence was relatively minor and the employee had no history of physical violence. So again, mitigating factors that we talked about earlier. But on the other hand, the employer had violence policies in place and the employee had been trained on those policies. The employee also had a disciplinary record that related to the poor treatment of coworkers. So it wasn't just a disciplinary record that involved sort of unrelated types of misconduct. It related to the poor treatment of coworkers. And the employee also did not accept responsibility and didn't demonstrate remorse for his actions. So some aggravating factors there that ultimately led to a finding of just cause for termination. So in terms of takeaways from cases relating to harassment and violence, it's important to remember courts will ultimately ask whether termination was a proportionate response based on all of the circumstances. And if you've trained your employees on your policies and you've conducted proper investigations, that'll all support a termination for cause. It'll give you leverage during settlement negotiations. It might stave off, demand letters and lawsuits from employees. And it'll all be evidence that you'll want to rely on if you do need to go to arbitration or you do need to go to trial at the end of the day. And with that, I'll turn it over to Matt.
Thanks very much, Anthony. The next area we want to look at is the area of drugs and alcohol. And there's many, many cases, of course, that we could have chosen. The one that we have was done purposefully because of it made it all its way up to the Newfoundland Court of Appeal, and because there was dispute at the lower levels. So it's quite interesting in that regard. And this case in particular had to do with not impairment or intoxication, but rather drug possession in the workplace. The employer in this case was an offshore petroleum production platform, and the employee, a unionized bargaining unit member who was a millwright and upon or just prior to boarding a helicopter to fly to the offshore platform, as part of the search policy, was found to have a small amount of marijuana in one of his pockets. Now, offshore drilling platform, needless to say, is a highly sensitive, safety-sensitive workplace. And so the employer had in place a drug and alcohol policy that provided for strict liability. And that means that if you're found to be in possession of illegal drugs while at work, your employment is terminated. It's important to note that at the time of this arbitration in 2018, marijuana was still considered illegal in this country. What we have then is a discussion amongst sort of the various levels of adjudicators going up to the Court of Appeal as to really what are the relevant items that one must take into consideration as to be able to determine whether or not, in this case, the employer had just cause to terminate. The arbitrator accepted the employer's disciplinary action. And in large part, he did so on the basis that it's a strict liability offense, and the employee, when asked about the marijuana, didn't offer, not even an alternate explanation, he didn't offer any explanation. He simply said he didn't know how it got in his pocket. That the arbitrator found was not sufficient and upheld the decision to discharge. The arbitrator's decision was judicially reviewed to the Supreme Court of Newfoundland and Labrador Trial Division, and at that court level, the court set aside the arbitrator's decision as being unreasonable. And the basis for that finding is that it viewed that the element of intention was critically important as part of this strict liability policy and offense, that the employee had to have intended to have the marijuana in his pocket while entering the workplace or possessing the drug in the workplace in order for the policy to apply. The employer, of course, didn't care for that decision, and so it was appealed to the Newfoundland and Labrador Court of Appeal. Unfortunately for the employer, the Court of Appeal reinstated the arbitrator's decision. Next slide, please. The fact that the employee had possession of the marijuana in his pocket at the time that he was entering or going to enter the workplace was viewed as being sufficient to violate the policy. And the Court of Appeal held that the employee's intention or lack thereof was not a necessary element to support the violation of the policy. In order to avoid disciplinary action, having engaged in the action, the employee needed to establish that some other explanation that he had taken care not to violate the policy. He didn't offer any explanation, much less a credible one. And so the arbitrator's decision was restored. Next slide, please. Again, it's important to note here, this case involves drug possession in the workplace, not drug possession outside of the workplace or impairment or possible impairment. It involves drug possession in the workplace, and as it relates to a safety-sensitive workplace. And those two elements together have in recent years been found to be something that arbitrators are not prepared to tolerate. In particular, there's a greater and greater emphasis as the obligations on employers with respect to occupational health and safety in the workplace increase, to ensure that again, someone who's engaged in drug possession in the workplace, in a safety-sensitive workplace, the fact of this individual's termination can act as a deterrent and promote the importance of safety to other employees. And that's something that arbitrators have accepted in recent years, and again was one of the reasons why the arbitrator, in this case, in the first instance, one of the elements as to why he upheld the decision to terminate. Next slide, please. Next area we want to talk about a little bit, because these cases with respect to inadequate performance or poor performance don't often make their way to the Court of Appeal level, but this one in Baker and Weyerhaeuser just this year did. Again, it's important to note, and I think Anthony touched on this in his foundational principles section, termination for cause for inadequate, poor, or substandard performance is a difficult burden for the employer to meet. Generally, in order for the employer to be successful in doing so, you have to have a properly documented progressive discipline with multiple opportunities for the employee to improve, including by way of performance improvement plans over an extended period of time. That administrative burden can often be daunting, and frankly, it's time consuming for employers. And so unfortunately, what can end up happening is the employer starts the process, they become frustrated, they'd like to end the employment relationship, and so they overstep their bounds and try to take shortcuts. And unfortunately, that doesn't often work when you're talking about termination for cause. And that's something that happened in this case, which is, amongst many things, it's an example of how to do progressive discipline the incorrect way. The facts of the case: the employee was a sawmill shift supervisor. He had 14 years of service, a relatively clean disciplinary record. In terms of where things became problematic is when, and this does often happen, when he himself got a new supervisor. The interpersonal relationship between the two was not a good one. And as time went on, it deteriorated. The new supervisor began by issuing Mr. Baker progressive discipline, including a written warning for poor performance, that he was not meeting Weyerhaeuser standards. Unfortunately, that performance management or progressive discipline stopped at the written warning stage. Instead, the relationship deteriorated further, and Mr. Baker's supervisor, essentially the documentation shows, got to the point where he was advocating internally for the company to terminate. And so when a small fire occurred on the employee's shift, the supervisor advocated for Mr. Baker's termination for cause on the basis that he didn't either properly report the fire or that he falsified the report. And unfortunately, in this case, as I'd indicated earlier, the importance of documentation is critical when you're building a case for cause. Amongst the many things that the trial judge upheld by the Court of Appeal found was that internal email documentation between the supervisor and management indicated that he was looking to fire this individual. And the court essentially concluded that once this fire incident happened, it provided effectively a pretext to be able to terminate for cause. A cursory, incomplete investigation took place, and the employer or the supervisor in this case found the basis to terminate for cause. Again, that's fine for removing the employee from the workplace, but ultimately, because this was litigated, the employer's efforts all came out into the open. And the court concluded, and the Court of Appeal concurred, that Mr. Baker's supervisor essentially was looking for reasons to terminate his employment. He'd just gotten fed up and relied on his personal bias against him. What's important about this case as well, and if we can turn to the next slide, please, is that there was misconduct identified, and both the trial division and the Court of Appeal acknowledged that and indicated that the conduct engaged in was worthy of some discipline, but that the employer failed to take the entirety or the totality of the employment relationship into account. His 14 years of service, the only written warning on file, and that at the end of the day was not able to show cause for dismissal, in part because the biased and true motivations of the supervisor were to remove the employee from the workplace rather than providing a foundation for just cause to be upheld. And can go on the next slide, please. As I indicated previously, again, when you're talking about termination for inadequate, substandard, or poor performance, the bar is a high one. And you have to establish reasonable, objective standards. You have to apply those consistently. You must demonstrate the employee failed to meet those standards. You have to follow through on the progressive discipline or the performance management. Not just give up halfway through, and in this case, essentially manufacture a case for cause. You must demonstrate that the employee had been warned that their employment would be in jeopardy if they continued to not meet the standards. So making it very clear to them as to what the outcome would be, termination for cause, if improvement doesn't occur, and to provide reasonable time to correct a situation. So, implementing a performance management improvement plan and then terminating a week later is not going to cut it. Again, the idea here, and this dovetails back to the progressive discipline in our earlier section, is the discipline is corrective rather than punitive, and not providing an opportunity to correct or improve the behavior is punitive in and of itself. So I think the biggest takeaway here is that when it comes to management of inadequate performance, there really are no shortcuts. And with that, I'll turn it over to Bruce and talk a little bit about some cases on safety violations.
Thanks, Matt. So the first case I'm looking at here is this Balzer decision. It's a Saskatchewan Court of Appeal decision, and it's a fairly interesting one. So the employee here, Mr. Balzer, was a propane coordinator, and part of his job involved filling and transporting commercial propane tanks. It's important to get a few background facts. for this case, and why ultimately the employer was successful in substantiating its cause position. So when he was hired, he underwent a lengthy training process, and he also completed additional training programs on the handling and transportation of propane. The employer was able to establish as well at trial that they had robust safety procedures in place in the event of an emergency. And in these policies and procedures, it was very clear, one, that the employees needed to follow them. And it was also made very clear what the consequences would be if they failed to do so, and that those consequences included discipline up to and including termination. So the important part there is, this is a safety sensitive role, but the employer was able to establish not only was he onboarded with a training process, but then over time, he was also given additional training. He signed off on that training, and they had all the records of that training. So one day, the employee is filling up a propane tank, and he makes a number of mistakes. He doesn't use certain equipment that he was supposed to use when filling the tank. He leaves the truck unattended on a number of occasions, which he's not supposed to do. He doesn't use a braking system on the truck, which he's not supposed to do. And then to kind of cap it all off, he pulls the truck away without disconnecting the fuel hoses. So the result is a propane leak that's pretty substantial that lasts for about 15 to 30 minutes. This is a major safety hazard. But it doesn't really stop there. There's certain protocols that he needs to follow. He doesn't really do any of those. He does call his immediate supervisor, who doesn't answer, but he doesn't even leave a message. He doesn't immediately notify any other managers or emergency contacts. He does call a colleague to come over, and then kind of sort of unexplainable, he just goes for an hour lunch. So he just goes and takes his lunch and doesn't lock the gates to the premises where there's been a substantial propane leak. Eventually, the colleague convinces him of the seriousness of the situation. He does report it up, and then he ultimately leaves his coworker in charge of the vapor leak. Next slide, please. So, as you can sort of see, I mean, the facts here are pretty egregious, and the trial judge looked at the totality of the evidence and found that there was numerous safety violations. And they didn't just occur when there was an accident, but it was how he responded. So again, he doesn't notify any emergency contacts. He doesn't call the emergency numbers he's been told to contact in the event of a propane leak or something of this magnitude. He doesn't notify his management in a timely manner. He doesn't secure the compound to keep people away from the scene. And then he goes for lunch without locking the premises, such that another car could come on the lot and that car could be a source of ignition. So he did a lot that was bad. There was a lot of poor judgment calls. And the court looked at this. And then they also looked again at the top, like I mentioned, okay, well, what did the employer have in place? And they were very satisfied that the employer had done its diligence. It had the training programs. It had the policies. It was very clearly established. And in the face of all this, the employee acted in such a way that he created such a substantial health and safety risk to others and a risk to the business that employment relationship was irreparably harmed. Next slide, please. So in that case, they were able to establish just cause on a single incident. But it's difficult to establish just cause on a single incident, even when it's a health and safety violation. Though not to be taken lightly, health and safety violations still require proportionality in any disciplinary response from an employer. So what this speaks to is it's why it's so important for employers to consistently communicate and uphold their policies regulating health and safety, and to make it clear that breaches of those can result in discipline, and to make sure that that training is continuous and you have employees sign off so you have that record. So again, this Balzer case is very instructive because his reaction was so egregious. And then on the other hand, the employer did a pretty good job of having those health and safety programs in place. Had he not been trained to the degree he was trained, and had he advised, had he followed the safety protocols after the mess up, which, admittedly he was responsible for, it's probable that, the employer would have had a difficult time establishing cause. Next slide, please. This is another Saskatchewan decision, and it's an interesting one because it has to do with time theft, which comes up not infrequently. So in this case, the employee was caught kind of falsifying her timesheets, and she was claiming pay for time that she hadn't worked. And it wasn't that egregious in terms of the amount that she was claiming, but it was the repetitiveness and the intention that really got her in trouble, combined with her dishonesty when she got caught with her hand in the cookie jar there. So basically, she was set to close up the store at 11, do administrative work until 11:30, but she kept ducking out about 20 minutes before 11, but yet she kept saying that she was there till 11:30 and claiming all that pay. So the employer got tipped off to this, conducted their investigation. And when they confronted the employee with its findings, the employee was then caught lying. And this can be a really huge linchpin when you're terminating for cause. The employee can do something wrong, but if they're caught being dishonest and lying in the investigation, that really, really bolsters a cause argument. So this first went to arbitration, and at the arbitration level, the misconduct was proven, but the board found that termination was a disproportionate response. It was then appealed to the lower court and up to the Court of Appeal, and the termination was upheld on a for cause basis. Next slide, please. So what the court looked at was, first off, time theft is a fairly material form of misconduct. It's quite significant. But again, not only was she dishonest about conducting the time theft, she was dishonest when she was confronted by the employer. And then she was also found to have been dishonest at the arbitration. Further factors that supported this cause finding, and these come up or they're going to be factors to consider in every for cause dismissal, but she was in a position of authority. She was trained how to document her hours. Again, time theft is serious, so unique to this situation. She never tried to take any ownership. She was not apologetic, and that the conduct was intentional and it was repeated. So on all of these grounds, the court was satisfied that the trust that was central to this employment relationship had been eroded. It could not be restored, and cause was established. The court also considered that there's very limiting mitigating factors here. And in every for cause dismissal, you have to think about these. I mean, are there other things that could excuse this, such that maybe cause dismissal is not appropriate, but a warning or other discipline is what should be administered? So here we have a short-term service employee. Generally speaking, it's easier to terminate a short-term employee for cause. It's a generalization, but here she only had 3 years of service. Again, the other mitigating factor here was these weren't isolated incidents. They were repetitive. A huge one that I see often is that this misconduct wasn't encouraged, but even more importantly, it wasn't condoned. Often you'll see fact patterns, or you'll see cases or situations with clients where, yeah, sure, the employer didn't encourage someone to do something wrong, but someone knew. Maybe a supervisor was new, or they let it slide with so-and-so or someone else, and then they really want to bust this one employee, but they've let it go for other people. That was not a mitigating factor here. There was no condoning of this type of behavior, so this was not a mitigating factor. Another one was that she wasn't acting in the spur of the moment. Again, this speaks to it being intentional and repetitive. And also, there was just no evidence of economic hardship. You could foresee a situation where she had something going on the home front that she needed the cash, which somehow might make her a more sympathetic plaintiff in front of an adjudicator or a judge. So none of those mitigating factors were present here, which is again reasons why the cause dismissal was upheld. Next slide, please. So key takeaways on theft. Theft is a bad one. It's often not excusable, but it does not always justify a for cause dismissal. Where it's repeated, where it's intentional, that bolsters your chances of establishing cause. And this is all compounded where you have a lack of remorse or responsibility, or the big kicker that I see is where someone's dishonest in the investigation. So if those things exist, then you're more likely to justify cause. Again, just being mindful to the mitigating factors and things that might, again, not excuse the misconduct, but might make cause disproportionate. And next slide, and then I'll send it back to Anthony.
Thanks, Bruce. And before we move on, I just want to piggyback off of Bruce's comments about, because we've talked about, earlier Matt was talking about investigating to gather documents, providing the employee with an opportunity to provide their version of events, to explain the misconduct, fairness and all that kind of stuff. But it amazes me how often employees lie during the investigation. I'd say more than 90% of the time, more than 90% of the just cause cases that land on my desk involve some kind of dishonesty during the investigation process. And it's just, from our perspective, from the employer's perspective, it's a great byproduct of the investigation process, even though that's not necessarily the objective to catch them lying. It happens often and we can rely on it. So just one advantage that I want to emphasize before we move on here. And so the last type of misconduct that we're going to cover off is off-duty conduct, misconduct that doesn't occur sort of within the workplace or on work hours. And in this case here, it involved a parking enforcement attendant who had 5 years of service. She was criminally charged with assaulting her domestic partner, again, outside of the workplace, in the sense of not during work hours or not with someone she worked with, And so even though she was criminally charged, the charges were ultimately dropped. The prosecutor concluded that there wasn't a reasonable prospect of a conviction based on the evidence they had. And while that process was going on, while that criminal process was going on, the employer conducted its own internal investigation. And as a result of that investigation, they ultimately discharged the employee for just cause. The employer was concerned about damage to its reputation, concerned that an officer or a parking enforcement attendant, someone who works for a police service, committing a criminal offense would damage their reputation as an organization responsible for upholding the law. So they discharged for just cause. Next slide, please. The union challenged the discharge by filing a grievance, and ultimately the arbitrator reinstated the employee. The arbitrator concluded that even though the employer was concerned, there was no actual or potential harm to their reputation. The public was not aware of the incident because there was never a public conviction. The prosecutor dropped the charges, and so public conviction there. And nobody saw the incident or the arrest. So it's not like there were witnesses going around talking to the media or spreading the news to the public. The employee did have a suspension on her discipline record, but the discipline didn't influence the outcome because the type of misconduct that it involved was different from the criminal charges that were involved here. And so the takeaway here is that off-duty misconduct, it can amount to just cause in the right case, but it's going to be difficult. And as an employer, you'll need to prove that the misconduct is prejudicial to your interests or your reputation, or that the misconduct is incompatible with the employee's duties. And as we've seen from this case, you might be concerned and you might think that the misconduct is going to damage your reputation, but actually convincing an adjudicator of that is something very different. And so with that, we're going to move on to our next section of the webinar here. Did the employer establish just cause?
Thanks very much, Anthony. And this is where the opportunity for you to participate with your answers to our polling question, did the employer not establish cause? And we'll kick it off with a relatively recent decision of the Alberta Court of Appeal. The facts are quite interesting. In this case, it's a dental laboratory which manufactures dental appliances and sells them to dentists. One of the shareholders in the business and a director of the company turned out had been engaging in certain conduct for quite some time before the board of directors and the other shareholders determined that they just had enough. Amongst the misconduct alleged, he was habitually late in attending work. And he was in the office. He only did a minimal or a nominal amount of work. He was someone who engaged in vulgar and abusive language towards his other shareholders in violation of policy. He failed to attend mandatory continuing education sessions, and he used his work computer to access pornography, including showing the pornography to other workers. Important facts here as you're trying to decide whether or not the employer established cause or not. The company had a policy which set out a 5-step process for progressive discipline designed to correct performance and conduct deficiencies. However, in this case, the employer never engaged that process. Before terminating the plaintiff's employment, it also did not issue any written warnings to him. And although it had a strict policy with respect to the appropriate and inappropriate use of office IT systems, including with respect to accessing pornography in the workplace, the court accepted evidence that the employee in this case had repeatedly accessed pornography for years on his work computer to the knowledge of the employer, and nothing was done about it. And then finally, there were regular management meetings in which issues with senior managers could be brought up, and these issues were not brought up at any time before the employer decided to terminate the plaintiff's employment for cause. So we can go to the next slide, the poll. Did the employer establish cause? And I like how that yes number is creeping ever so lower, because those of you who answered no are correct. At the end of the day, the court found that the employer had proved that the alleged inappropriate conduct took place. The problem is that in many instances, they'd condoned it as it relates to the pornography on the computer, and then didn't ever engage in any progressive discipline. Again, another important reason for progressive discipline. If the misconduct occurs and you don't discipline for it, the risk is that you're viewed as condoning it by the court, and you can't rely on it later on as being something that's worthy of discipline. In this case, the court determined that progressive discipline ought to have been used. It wasn't. And so lesser sanctions could have been applied and ultimately could have built up to a case for termination for cause, but because none of that was present in this case, the employer did not establish cause for termination. And for our next case, it's on to Bruce.
Thanks, Matt. Obviously mindful of questions as well, so I'll try to go as quick as I can, but to do justice to this, this is an interesting decision. So this employee had 20 years of service, or close to 20 years of service, and a female colleague had alleged that he had made some inappropriate comments with respect to some sexual harassment. So some of these comments had to do with whether she danced on a table after a company dinner, whether she should sit on someone else's lap at a workplace meeting, that alleged or alluding to the fact that she had mentioned something about gardening outside, and he said, well, any reason for you to bend over and go down on your knees, just kind of terrible things like this. Some really bad gestures about sexual gestures and comments about sort of being on top, again, in sort of an innuendo fashion. The employer conducted an investigation and ultimately decided not to terminate for cause, but gave this employee the opportunity to take remedial action, including sensitivity training, and to apologize to the complainant. But he refused to apologize. So following the employee's refusal on the apology, the employer terminated for just cause. And at the lower court, this individual was awarded 20 months notice. So then this went to appeal, and you can go to the next slide. So in terms of whether on the Court of Appeal, were they able to find that the trial judge had it wrong, and in fact, the company did have cause here. And I'll just give a moment for these to be looked up. Okay, the numbers are moving around, but they're moving in the right direction. So you can go to the next slide. And yes, the Court of Appeal looked at this and they said, look, the comments made were sexual harassment. They were inappropriate, they were demeaning. And even though this was a 20-year employee, there was anti-harassment policies in place. He knew about the policies. He'd been trained on the policies. He had a position of trust, and the nature of these comments was so significant. So these factors combined with a failure to apologize, a failure to be remorseful, substantiated the employer's position on cause. And the only thing I'll just say lastly on when it comes to things like sexual harassment here, the needle's moving, and what was not cause a decade ago may be cause now. Not all acts of sexual harassment are going to constitute cause. And so this is always, again, just a really important reminder for those workplace policies, the training, the sign off. What we're seeing is where employers are taking workplace harassment seriously, these types of breaches are more likely to result in a successful cause dismissal.
And for our last case here, we have a case involving an employee with 16 years of service. First 13 years were in the role of a firefighter, and the last 3 years were in the role of an assistant fire chief. The employee had received positive performance reviews and had been described as an exemplary employee. But the reason we're talking about this case is because the employee's driving license was suspended for driving while intoxicated. He was pulled over by the police while he was off duty, and he failed 2 breathalyzer tests. At the time, he was driving a fire department vehicle, but he wasn't on duty, and the only marking on the vehicle was the fleet number. There was no other fire department logos or branding on the vehicle. And after the incident, the employee immediately reported it to his employer, and he was forthright and honest about what had happened. So, did the employer establish just cause? We have, again, a long service employee here, but at the same time in a leadership role, breaking the law, committing an offense. Is there just cause? All right. Looks like, I don't know what's going on. Looks like some people are wavering, but ultimately, no, there was no just cause. The court rejected the just cause argument. The court accepted that community members would have expected the assistant fire chief to avoid risks that would jeopardize public safety, but he was allowed to use the vehicle off duty. The public wouldn't have known that the vehicle belonged to the fire department because there weren't any markings on it. The public didn't know the vehicle belonged to the fire department. The public didn't know about the license suspension. He wasn't representing the fire department at the time, and he was not the public face of the fire department. So again, takeaway here is off-duty misconduct can amount to just cause, but you'll need to prove that it's prejudicial to your interests or that the misconduct's incompatible. And with that, I'll turn over to Matt.
Thanks very much, Anthony. And before we get to answering some questions, just to wrap up the as part of the formal presentation by identifying a couple of keys to success as you strive to make that determination for just cause case stick. Again, none of these will be surprising, but they're good to have down again in front of you and for reference purposes. Clear expectations, setting those out to the employee so that even though it may be obvious, putting in writing the expectations that you have for them and making it clear to them the consequences of the failure to adhere to those expectations. Patience, that's key. We've seen that through many of the cases that we reviewed, particularly when it comes to progressive discipline. Process, not only having a process, but using and adhering to that process. Being consistent, not playing favorites. Proportionality. Does the offense justify the discipline imposed? And then another thread you've seen throughout the presentation is the importance of good documentation. Ultimately, at the end of the day, if you're going to terminate someone's employment for cause, whether in a unionized or non-unionized setting, there is a good chance of litigation. And that means that the burden in all of these cases in a discharge for cause is on the employer. And having good documentation to support your decision to terminate really cannot be understated. And with that, I can tell you we are closing in on about 40 questions received either beforehand or during this presentation. So there's a lot of interest. Thank you very much for that. I've been looking at some of them during the presentation, and they're terrific. We will go through as many we can as in the next 10 minutes or so. So this one has come up a couple of times, actually, and it's one that I'm still often asked. The concepts of termination for cause and without cause are well known, but the majority of terminations include factual elements that fall somewhere in between. Will quasi-cause ever be considered in determining notice? I don't know, Bruce, are you able to take that one?
Yeah, that's a pretty straightforward one. So no, you either have cause or you don't have cause. There really is no in between. And someone terminated without cause, but has maybe a track record of poor performance and all that, those factors are going to do very little, almost next to nothing. So either you have it or you don't is the answer on that one.
Great, we're all off to a positive start in terms of the questions. Let's see. Please comment on situations where an employee who engages in misconduct raises a potential human rights issue to explain or defend misconduct. I think I can take this one. Yeah, surely this is something that you as legal counsel or human resources professionals or managers or supervisors have come across many times. And the law is pretty well set in terms of the employer's obligations. If someone raises, and it's demonstrated, for example, by way of a substance abuse professional assessment, that the misconduct that they engaged in was as a result of, or the drug or alcohol addiction contributed to that, the duty to accommodate that individual is going to apply. Human rights legislation is paramount in these cases. In terms of the outcome and next steps, that can depending on what the misconduct is. If, for example, if the misconduct itself is a DUI, so related to the actual alcohol addiction, that, I'll be honest with you, that is going to be potentially a long road into the future to deal with that as part of the accommodation process, assisting an employee to enter rehab, to demonstrate that they're free from drugs or alcohol. In other situations where, for example, there's a safety sensitive incident, an accident, and the individual discloses that they suffer from alcohol addiction and they were intoxicated at the time. Again, you are likely going to have to accommodate in the first instance, but what you can do is to put in place the conditions for success going forward in the form of something like a last chance agreement, which indicates that, for example, any future misconduct of this or a similar nature will result in termination for cause, and an arbitrator has limited or no jurisdiction to substitute a lesser penalty. So there's no doubt that this is one, again, it's one of the more challenging areas in employment law. But again, hopefully that gives you a little bit of insight on how to deal with it. Let's see. If you assert cause where you do not meet the legal threshold, i.e. poor performance for cause, what is the risk of a bad faith claim? Anthony?
Yeah, I can take this one. I think as long as you aren't fabricating cause at the 11th hour to avoid termination pay, and as long as there are legitimate reasons or a legitimate belief that there is just cause for termination, I think you're probably safe to raise just cause allegations. It's where you are raising at the 11th hour, or where you know that the misconduct would clearly not amount to just cause, but you're going to raise it anyways, just as leverage in settlement negotiations. And I think a good way of thinking about it is, if you terminate for just cause and you rely on whatever misconduct you're going to be relying on, are you going to be comfortable answering at an examination for discovery the question, did you honestly believe that there was just cause for termination? And if you're asked that question and you can't say, yes, I honestly believed that there was just cause for termination, then it's going to be an allegation of bad faith. You didn't honestly believe it. You just raised it as a tactical maneuver. So yeah, just to summarize, anytime you're raising just cause allegations, there can be risks of bad faith claims, and there is the odd chance that a court is going to penalize you for that, but with additional damages. So consider it, take it seriously, and ask yourself whether there's a legitimate basis. If it's arguable, that's not the test. It's whether you're acting in good faith.
That's a great comment. Let's see here. Okay, we have an employee who is competent at her job but is unable to get along with others. Get along in quotes. We have constantly have complaints about her condescending and insulting attitude. Can this be a reason to terminate for cause? Bruce, can you assist?
This one's more complicated than that first one. I think based on that question, it would be difficult to establish just cause without knowing more facts, but that would be a very difficult one. I think the best approach is going to be the performance management and coaching, and even then you may still not get to cause. If there was elements of, a really toxic workplace, harassment, bullying, things like that, that might get you over the line and into a cause territory. But absent that, it'll be quite difficult. So all I can say in terms of recommendations is to do that analysis, consider a performance improvement plan. And I think, a lot of this stuff also comes back to why in our employment agreements, it's really important to have tight termination clauses, because these are situations where you're better to rely on a without cause termination that limits to statutory minimums, because cause would be very difficult, I think, here.
Thanks. Okay, I'm very mindful of our time, but I think we've probably got time to squeeze in one more question. What information or documentation would or can be used in litigation or arbitration, emails, letters, etc., as this may influence how documentation is used to support or hinder a case. Okay. Yeah, I mean, we do get this question a lot. And again, we talked about the importance of documentation. And so understanding that when we talk about documentation, that can mean many things. It's not just letters. It can be emails. It can be, and more so, it is text messages. It's WhatsApp messages, internal IM messages. All of these documents are, A, they can be relied on, but B, they can be subject to production and compelled production from the other side. So it's a double-edged sword in some ways. In the age of electronic communication, documentation can help you. It can also hurt you in terms of, perfect example, for example, is that one case that I talked about with the sawmill supervisor, where the supervisor was essentially emailing internally, not privileged communications, advocating for termination for cause before the incident that they relied on to purport to terminate for cause. That's something that's producible, either in a wrongful dismissal trial or an arbitration hearing. So again, our advice on that is, again, email documentation can be very helpful for you, but also be careful in terms of creating a paper trail that may hurt. And that means, off the cuff remarks, opinions, all those sorts of things. If you feel that you need to do those, have in-person conversations with your peers, or use the telephonic device that is on this iPhone rather than the email or the text message. And with that, I think we have reached our time limit. This has been a really terrific session. I want to thank everyone as well for the great questions. Like I said, I'm sorry we couldn't get to all of them, but thank you so much for joining us today. And I want to thank Anthony and Bruce for really their terrific insights into what is always an interesting area. Just a reminder to everyone, if you have an opportunity, and can take 5 minutes to complete the survey if you haven't already done so, that'd be terrific. And our next webinar, which we're happy to bring to you, is coming in November. And so keep an eye out for an invite in your inbox. And with respect to any upcoming events, you can always check the Fasken Institute section on our firm website, fasken.com. And so with that, on behalf of Bruce, Anthony, and myself, thank you very much for attending, and have a great remainder of the afternoon.